3, 2, 1.
Good evening. Welcome to the February 22nd, 2024 Rental Housing Committee meeting. Due to our hybrid environment, we will no longer have speakers line up to speak on an item. Anyone wishing to speak to address the committee in person would complete a green speaker card, indicate the name you would like to be called by when it's your turn to speak on the item, and you'll please complete one speaker card for each item on which you would like to speak and turn them in to city staff as soon as possible. Recently, regional and local elected and appointed bodies have been subject to disruptive racist verbal attacks by anonymous callers during virtual public comments. The City of Mountain View is fully committed to racial, religious, and cultural equity and justice as we strive to create a welcoming, safe, and inclusive community for all. This committee welcomes respectful and non-threatening public comments regarding matters over which the committee has jurisdiction. Comments deemed otherwise pursuant to the Council Code of Conduct and the Government Code may be grounds for immediately terminating a speaker's comment period. So the meeting is called to order at 7:03, and now we should go to roll call. Andrea?
Thank you. I will begin with Committee Member Balch.
Present.
Committee Member Brown.
Yep.
Committee Member Ma.
Aye.
Committee Member Cox.
Here.
Vice Chair Rosas is absent. And Chair Keating.
Here.
Thank you.
Our next item is the consent calendar, and these motions will be approved with one motion, and there is just one, the minutes of our last meeting. Is there any public comment? We have no one here in the physical audience. Is there any online?
There's no comments.
Okay. And is there any desire to pull the one item by the committee? Seeing none. Is there any discussion? Seeing none. Can we have a motion to approve? And a second?
Yep.
Okay.
Sorry, who motioned for that?
I did. It should be on the screen. Kevin.
I see.
Do you want to read it out loud?
It's okay.
Okay.
Okay, so we have a motion to approve the minutes, consent calendar, and a second. And Andrea can, now we're going to use Granicus to move on to vote.
Correct. You should be able to vote. Perfect. Okay. Motion passes unanimously. Thank you.
We have used Granicus to vote now. Very good. We are now open our meeting for oral communications. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. Are there any speakers? There are no in-person speakers. Are there any online speakers?
There are no online speakers.
Okay. So that completes item 4. Item 5 is an appeal hearing. Appeal of the hearing officer decision on petition number C-232-40026. The Rental Housing Committee, in hearing the appeal, is acting in a quasi-judicial fashion and will conduct the hearing in accordance with those standards. Staff will detail the appeal hearing process in their presentation. Before we get started, the Rental Housing Committee members are required to disclose any communications that they have had with any of the parties to the petition or the parties' representatives and the substance of those communications since the date the petition was filed. The decision of the Rental Housing Committee is to be based on the record presented to the hearing officer. Information disclosed to an RHC member that is not part of the record is not to be considered in the hearing. Do any Rental Housing Committee members have ex parte communications that need to be disclosed? Okay, seeing none. So we will now proceed to the hearing. So our hearing begins first with public comment. Are there members of the public who are not parties to the petition who would like to speak? In-person public comments will be called first. We have none. Andrea, are there any Zoom speakers?
There are no online commenters.
Okay. And we will move now to our staff presentation.
Thank you. We can go ahead and go to the first slide. So the purpose of this item is to consider the tentative appeal decision and either accept the tentative appeal decision or modify the tentative appeal decision with instructions to staff citing appropriate evidence in the record. In this presentation, I will go over the decision process, the schedule for the appeal hearing this evening, as well as the summary of the petition and the appeal. So the role of the Rental Housing Committee tonight, when it comes to questions of law, is to exercise its independent judgment. Questions of law are those related to, for instance, statutory interpretation. This is called de novo review. As the chair mentioned, for questions of the fact, the RHC must determine whether or not each appealed element of the hearing officer decision is supported by substantial evidence, in which case the Rental Housing Committee is not reweighing the evidence or relitigating the issues. The appeal is based on the records submitted to the hearing officer, meaning no new evidence should be presented by the parties or considered by the Rental Housing Committee that is not in the record for the hearing. And lastly, this does not mean that the Rental Housing Committee has to come to the same conclusions as the hearing officer. Slide. Staff does not recommend doing a de novo hearing this evening. This would require a new formal hearing, which would take up significant time and would require a lot of work to prepare for the Rental Housing Committee. The existing evidence in the record is sufficient and upon which to make a determination, and the existing record demonstrates adequate review and ample opportunities for the parties to present relevant evidence. So the scope of the decision, the tenant's petition in this case defines the scope of the hearing officer's decision, and appeals of the hearing officer's decision are limited, limit the scope of the Rental Housing Committee's review on appeal. So the Rental Housing Committee should not consider issues that are not raised by the appeal in its review this week. I think we can go on to the next slide. So the schedule for the appeal, staff will first complete its presentation, and then the appellant will be provided 10 minutes to make their presentation, followed by a 10-minute presentation by the respondent, and then each appellant and respondent will have 5 minutes for rebuttal. Thereafter, once all of the parties are done with their presentations and rebuttals, the Rental Housing Committee can ask questions to staff, to the appellant, or to the respondent. And lastly, the Rental Housing Committee should deliberate and make a decision on whether to affirm or modify the tentative appeal decision. So getting now into a summary of the petition, this is a tenant hardship this appeal arises out of a tenant hardship petition. The tenant hardship petition sought relief from a 10% rent increase, which includes the 5% bank annual general adjustment increase for 2022 and the 5% annual adjustment increase that is currently effective for 2023 to 2024 on the basis of the tenant's household income. In this case, usually I move past the petition summary, but I do think it's important to go over some of this as the decision in the prior petition between these parties does come into play tonight. So as you'll see on the summary, in July of 2022, there was a petition submitted by the tenant based on unlawful rent due to concessions that were provided during the initial term of the tenancy, and a decision was issued in that petition by the hearing officer, in essence providing the correct base rent for the rental unit of $1,416.25. That decision was appealed to the Rental Housing Committee. On appeal, the Rental Housing Committee affirmed the appeal decision, which upheld the hearing decision in its entirety. What that means is that essentially the Rental Housing Committee upheld the determination that the base rent, the correct base rent for this unit, it was $1,416.25. And then we get into a year later, which is the submission of this new petition, and I won't go through that summary or that timeline. It's not as relevant. But I did want to provide a little bit of background about the prior petition. So a summary of the hearing officer's decision in the instant petition, the one upon which the appeal is based tonight. The hearing officer determined that the tenant was entitled to relief from the banked 2022 increase of 5% because her household income did not exceed 100% of area median income for Santa Clara County. And this is provided for in Chapter 7, Section C6 of the CSFRA regulations. The 2023, the decision then went on to provide that the 2023 annual general adjustment of 5% should be applied to the lawful rent of $1,416.25 rather than $1,444.55, which was the amount of rent that was in the rent increase notice issued by the landlord in August of 2023, which would bring the lawful monthly rent for this unit to $1,487.06 beginning October 1st, 2023. And the reason for that was that there was no evidence in the record of there having been a valid rent increase notice issued by the landlord to the tenant after the decision, after the appeal decision in November of 2022. And lastly, the hearing officer's decision determined that the tenant was entitled to a refund of $28.25 per month for the 10-month period from December 2022 through September 2023, which again was due to there not having been a valid rent increase notice issued after the determination in the prior petition, as well as a refund of $104.44 per month for the 3-month period from October to September of 2023. And the reason for that was that the tenant had already started paying the rent increase in October of last year once it went into effect, and during the time that the petition was being processed and going through the hearing process. as well as any overpayments for January 2024 subsequent months. That okay, we can. So the appeal, on appeal, the landlord raises the following issues. That the hearing officer abused her discretion by inquiring into and determining the base rent to which the 2023 AGA should be applied as $1,416.25 because this exceeded the scope of the petition. And second, the hearing officer erred in determining that the lawful rent at the time of the petition was $1,416.25 because the landlord and tenant agreed to $1,444.58 as the correct rent in compliance with the hearing officer's decision in the prior petition between the parties dated October 6, 2022. So the tentative appeal decision would affirm the hearing decision in its totality on the basis that the hearing officer had authority to provide such other relief to the tenant that furthers the purposes of the CSFRA, and that can be found again in the tenant hardship petition regulations. In addition, hearing officers have the ability to raise issues sua sponte, which is a fancy legal term meaning on their own or of their own volition, particularly where the resolution of that issue is necessary to resolve claims that were actually raised in the petition. And lastly, the hearing officer did not err in determining that the lawful rent for the unit at the time of the petition was $1,416.25 because any agreement between the parties was invalid pursuant to the non-waiverability provision of the CSFRA. So after the tentative appeal decision was issued, the appellant did provide an additional response to the tentative appeal decision. The appellant's response to the tentative appeal decision raised an additional issue, which was that the rules requiring a rent increase notice to be provided were being implemented inconsistently from one hearing decision to another, leading to confusion about what the appellant must do to comply with the decision. Specifically, there was concern as to why, a determination was being made that a proper rent increase notice was needed to raise the rent after the decision in October of 2022, but that none is being required in the decision that was issued in the instant petition. So in response to appellant's response to the tentative appeal decision, there are a number of circumstances that are different between the October 2022 decision and the hearing officer's decision in this petition. The first is that in the prior petition, the landlord did not serve a proper rent increase notice at any time after the October 2022 decision was issued for the 2% increase. But the landlord did, in this case, serve a valid 10% increase notice in August of 2023. In addition, the 2% increase imposed in December 2022 was done so via agreement of the parties, which is expressly prohibited by the CSFRA. The CSFRA, as I mentioned, has a non-waiverability provision that provides that the parties cannot enter into an agreement that would waive any of the tenant's rights under the CSFRA, including the right to a valid rent increase notice. In the instant case, on the other hand, the hearing officer has issued an order altering or superseding the valid rent increase notice served in August. So that's sort of the difference in how these rent increases are being imposed. In addition, the October 2022 decision neither authorized the 2% rent increase nor mentioned subsequent rent increases at all. Whereas in the instant case, the hearing officer's decision explicitly addresses the issue of the notice of rent increase for the 5% AGA increase for 2023. So fiscal impact, you've heard this before, but any decision by the Rental Housing Committee on appeal, including adoption or modification of the tentative appeal decision, could potentially lead to litigation, which would have fiscal impacts. However, one of the purposes of having this appeal process is to ensure that hearing decisions are in fact legally defensible. And so the appeal process to the Rental Housing Committee reduces the overall risk of legal liability and legal expenses to the program. The staff's recommendation is for the Rental Housing Committee to consider the tentative appeal decision and either accept the tentative appeal decision or modify the tentative appeal decision with instructions to staff citing appropriate evidence in the record to support any modification. Thank you.
Thank you. So moving through our appeal process, next is for the appellant landlord to speak for 10 minutes. And if they are in Zoom, they should click the raised hand button in Zoom.
Mr. Walter, are you able to unmute? Oh, there you are.
Yeah, it took me a minute to find the raised hand. Ready to go?
All right, whenever you're ready.
Okay. Good evening, and thank you for the time here. I kind of want to summarize a little bit more the petition and the process, and if the RHC followed what was just presented, I applaud them, because I've been working on this for months, and even though I know it, it's still totally confusing. So hopefully you can appreciate the necessity for consistency and the lack thereof here. The latter petition, the one we're here for, was done for tenant hardship. That was the scope of the petition. Black and white, the household income didn't meet the required, so the banked rent increase could not be applied. I agree with that 100%, no issues there. But the rental housing, the hearing officer went beyond that and calculated what the rent could be, which I don't have a problem with, but then went even further and said, oh, there wasn't a written rental notice increase for the increase done back in October of 22. That brings up the previous petition. The previous petition said that we went through it, and the hearing officer's decision was the parties shall calculate the exact amount demanded. The petitioner and myself, we didn't come up with an agreement. We followed the decision from that last petition. That last petition decision was very short and brief. So we followed that. We figured out what credit was due. We figured out what the rent should be. And we followed that. And I think Ms. Williams, the petitioner, would be the first to agree with that. The current petition is much more detailed than the decision. And the fact that the hearing officer has the authority to go well beyond the scope, I would consider a bit overreaching. However, if it was consistently implemented, i.e. the original petition back in 22, if that hearing officer was just as thorough and did the exact same things that this hearing officer did, we wouldn't be here right now. Although the current the current decision states that there was no written rental agreement, rent increase notice provided. I don't know if everybody followed why it was required on the original one, and not necessarily on this petition. But honestly, I have zero confidence, and don't, if I come back in a year and follow this last petition decision to a T, it says I can charge the 5% on the original base rent retroactively to October 2023. Well, I can't write a rent increase notice and backdate it, so apparently it's not needed. Yet I followed the decision from the original petition, and the rent increase apparently was needed, although it was not required, it was not stated. At a minimum, I need to know, I need it documented, I need it recorded properly and officially that if I, the landlord, followed this petition decision to a T exactly as it's written, that no other CSFRA requirements are required by the landlord, because I don't trust anybody. Because I in good faith followed the decision from the petition back in 2022, and apparently it wasn't sufficient. I don't know how many of you people knew or the legal terms that were provided in the summary, but it's very clear that when these petitions and appeals go into the back room and the lawyers get a hold of them, I mean, they're referencing case law, and there was no attempt to pull anything over on anybody. I was in good faith complying with the petition hearing decision and complying with the CSFRA, and it has come back to bite me. And both staff, they need to do better. They need to be consistent. I mean, it was essentially the same petition. Why didn't the first hearing officer detail the exact thing that the exact numbers, what was required for the credit, what the base rent was, what the base rent increase should be? It's just not consistent. And yeah, so it was said that a valid rent increase this time was done for 10%. Well, and the increase that I did back in 2022 for 2% was on the wrong base rent. So because it was on the wrong base rent, that was not a legal increase. Well, the rent increase this year was wrong because it can't be 10%. So on one of them, the increase amount was wrong, and apparently that's okay. But on the last one, the base rent amount was wrong, and that's not okay. But the rent increase amount was right. The Rental Housing Committee is not going to overturn this decision. I honestly don't understand the reason for it, but it does give me a chance to bring out the fact that there is a lack of consistency. And the Rental Housing Committee and staff are responsible for the hearing officers. They tell them what they're supposed to do. They need to be given better direction. Every decision that I'm ever involved in, again, I'm going to require, as I want for this one, that it says what more I have to do as a landlord to be in compliance. Do I only have to follow the decision? Well, if that's the case, that decision better cover everything that needs to be done. The next time I see a decision that is as vague as, the parties shall calculate the exact amount demanded, I'm going to require that be expanded, and that, Mr. Hearing Officer, you need to write down everything. What's the base rent? What's the increase? If there's credits, you need to write that down. It's just a severe lack of consistency, which leads to confusion. And, hopefully you can appreciate that. Again, I don't expect you to overturn it. But you need to do better. You need to do better, and you need to have the people that I pay for, that you're in charge of, do better. So that's all I have. I actually need to apologize to Ms. Williams for dragging her through this. She actually, if she's here, she doesn't even really need to be here. She's not going to have much to say. But if she's here, I apologize for bringing you through this. It's just a landlord trying to follow the rules and apparently not doing a good job of it. So that's all I have.
Thank you. Moving through our process, next is 10 minutes for the respondent tenant to address us.
Hello, can you hear me? Okay.
Yes, we can hear you.
Okay, great, thank you. Hi, yep, I'm Rondalyn Williams, originally the original petitioner of the hardship petition this time around. Yeah, I think, I like Mr. Walter said, I don't really have a whole lot to add. I will just say that, so when we got the decision back from the first decision, I did think that what we were asked to do was to determine what the next, or, based on the decision, we were to determine what the rent was supposed to increase to. We knew that the base rent was $14.16.25, but that it was supposed to increase by 2%. And I believe that that's what we did. I emailed the property manager. We calculated it over email, and I think I sent that in. The landlord and the property manager refunded me for, I'm not sure how many months, but several months, for when I was paying more than the 2% increase. And then they changed the rent moving forward to the new amount. I think at that point it was $14.44.58. They did send me a legal 30-day notice of change of monthly rent that was to begin on October 1st of last year, with a 5% HEA increase and then 5% banked increase. I did file the petition for the hardship relief for the 5% banked, to just receive the 5% HEA increase. I don't fully understand this process. So if I'm doing anything I'm not supposed to do, I apologize. But I'm not sure, what the policies and things are. So whatever is policy, whatever is supposed to happen by policy, I'm happy to receive that decision. That is all. Thank you.
Thank you very much. So, if desired, the appellant landlord now has 5 minutes to further comment and officially to rebut any statements made by the tenant.
Thank you. I will just reiterate the fact that Ms. Williams just agreed with the fact that she and I both felt we were following the decision, and we did what was asked of us by the decision. We calculated the credit due. We did that appropriately, documented it. We agreed that the rent increase was what it should be, documented that, and moved on. So we were both 100% thinking we did what was requested and required by the first petition. I'm not going to go back and forth with staff and listen to more legal stuff and be cited more case law on why this or that. But again, we both agreed, that the petitioner and myself, that we did what was requested in that first petition hearing. Probably to both of our surprise, we didn't. If that's the case, again, staff needs to do better. And we're not lawyers. Ms. Williams said she doesn't understand the process. I unfortunately am buried with this process, and I don't understand it, obviously. So staff needs to do better in directing and guiding us, through this maze of requirements and procedural things that need to follow. Again, I have zero confidence that I will be in compliance if I follow this latest petition decision to a T, because it does not say I need to provide a written rent increase, and I'm being called out for not doing that on a previous decision. So I have zero confidence that I will be in compliance, and I don't know what to do to gain that compliance. All I can ask is that it gets formally documented, that it specifically says, if the landlord follows this decision as it's written, there is no other requirement for the landlord to be compliant with this decision. Something that I can, wave in front of the next hearing officer's eyes when they say, hey, you didn't file a legal rent increase. I need something that holds up, that is correct. And obviously I can't come up with the fact that it's correct, because when I think I'm doing things right, apparently it's not. So staff and you guys need to document this and make it, fact. Make it as clear as day for not just lawyers and legal people that can follow the case laws cited in this and that, but for the landlords and the tenants. If we're doing what we think is right, and then staff turns around and says, hey, you're not doing it, who is this for? Are you trying to, we're trying to work together. The tenant and the landlord are trying to work together, and the CSFRA apparently is so complicated that we can't do it without help, and the help that you're providing is not sufficient and not consistent. So please do something formally that tells everybody, me included, and the tenants included, that if the landlord follows this decision exactly as it's written, that they will be in full compliance with the CSFRA, and that will be the end of it. But until that's done, I have zero confidence that it's not needed, and that I won't be in this same boat a year from now for the same reason. So please do something. Thank you.
Thank you. And next, if desired, we allow 5 minutes for the tenant to respond or rebut.
Yes, I am just in favor of whatever is spelled out in the policy or laws. That's all.
Thank you. So in our next section, there are 2 bullet points. I think we can take them at once, although the first one says rental housing committee members, do we have questions for staff? And then the next question is, do we have questions for the landlord or the tenant? So I think we'll move to Granicus now, to our software, so I can see who has questions. Just a moment. Committee Member Balch?
Is this the section to ask staff now first? Okay. Can the staff comment on, so my interpretation of what we've just heard is that the prior petition that established what the allowable base rent would be, that then had the landlord and the tenant work that out to the instructions of that hearing. My interpretation is that for that to have been valid, the landlord then needed to provide a written notice of rent increase per the CSFRA's normal requirements. So my question is, first of all, is my interpretation correct? And if so, what are we doing to, as a staff, to make clear which requirements apply or not apply at different junctures, for lack of a better term, during the process, right? Even when the judgment is made by the hearing officer, it's follow-up responsibilities are required. So I would just like to understand, how is that communicated to the parties involved? Thank you.
Sure. So I can take the first part of this, and then maybe someone, Patricia, maybe you can take the second part. So first off, I just want to clarify that the language that we're talking about in the prior decision, it was misinterpreted, whether by the landlord or the tenant or both parties. So that language in totality says the parties shall calculate the exact amount demanded and retained by respondents, and an appropriate refund or rent credit shall be issued to Ms. Williams within 30 days of the date of this decision. So that language was directing the parties to determine the amount of overpayment that was due to Ms. Williams from the landlord because of prior overpayment. It was not directing them to calculate the correct rent for the unit together. That is not what that language was intended to do. There's other language in the decision that very clearly states what it says the base rent for the property is correctly calculated as $1,416.25 per month. So it says what the correct rent was at the time that the decision was issued. It does not make any mention as to, we're waiving the landlord's requirement to issue a rent increase notice to increase the rent after this decision is issued. Unlike the current decision, which does have that specific language. It says that in the instant petition that the hearing officer's decision is superseding the notice that was provided by the landlord, and that the lawful rent for the unit is the $1,416.25 plus the 5% annual general adjustment for 2023. So that is the difference between the two decisions, in case my presentation was not previously unclear. As to, and before I turn it over to Patricia or Anki to answer the second part of the follow-up, I will say that this process does provide for compliance hearings. If there's confusion or lack of clarity around what a landlord needs to do in order to comply with the decision. And so if there was confusion as to what that language in the prior decision meant, that process was available. There's also the informal process of reaching out to staff to ask them, hey, what did this language, what was it intended to mean? And staff can always ask the hearing officer for that type of clarity. So yeah, I'll now pass it to staff to provide any additional clarification they might have on that.
Good evening, committee members. Thank you, council. Just to further clarify the process, the decision is issued and then the parties have 15 days to appeal the decision. In this process, this particular petition went to appeal, this first petition. At no time was there a question brought to staff about how to lawfully increase the rent thereafter the petition decision. The decision also spelled out pretty clearly, as council described, what the expectations were in the decision, and at no time did any of the parties reach out to staff with any kind of questions regarding clarifying the application of future rent increases. I'd also want to point out that it is state law to give a 30-day written notice, not just the requirement under the CSFRA. Hopefully that helps clarify some of the staff process here.
Yes, thank you both.
Committee Member Brown.
Thank you, Chair. Okay, so to staff, how many petitions have we had for inadequate notice of rent increase, approximately? Is this a common occurrence?
This would be bundled into the unlawful rent petitions. I would have to go back and check specifically for that type, but we have had them in the past. And they're often due, a rollback because of that, because the notice was not increased. So I don't think we've had any petitions in this situation that were filed for this particular error issue where they have not been found in favor of the petitioner, because it is written notice is required.
Okay, and then is there an FAQ or other resource outlining the requirements in section 1707, particularly item C and the related regulations? Is this available for landlords to access somewhere on our site?
About it being state law that they provide written notice?
And but also the section of the CSFRA for the requirements, the 1 rent increase per year, notice of rent increase required, banking, the limit.
Yes, that is available
I know it's in
on our website as well. It's in FAQs, it's available on the website, and there's also language, I believe, in the required information sheet that talks about how rent increases can be given.
All right, thank you.
Committee Member Cox.
Yeah, I'm just wondering, I mean, we talk about the idea of sending a written notice, for the rent increase. Does the city have forms that can be used to officially notify somebody, or does the landlord just kind of wings it when he writes the stuff up?
Well, the city does provide a template that property owners are able to utilize for a rent increase. And it's available on our website. And it was used by the property owner in this instant case for the current petition that we're looking at to notice the 10% increase.
Okay, but it wasn't for the 2% increase that he tried to do.
Yeah, I just want
to
add to that we don't provide legal forms. That is not the job of the city. What we do provide is an annex to a rent increase notice in case of banked increases. That's where they can exactly calculate what a banked increase can be. Most landlords are a member of the CAA, and they provide those types of rent increase forms and all other types of rent forms. for
Okay,
landlords.
so in this particular case, no such form was used. It was just an informal agreement between the tenant and the landlord about how much that rent would be. It was not, there was no written paperwork on it.
There was no written notice. And I do just want to clarify, it is state law that you must give a written notice of a rent increase. It is not just the CSFRA.
Another question, I mean, we hear a lot about, you know, these different landlord workshops that are available to help make people understand what it is they need to do to be in compliance with CSFRA. Do you cover in the landlord workshops this idea of how to calculate the base rent and that kind of thing?
That is correct. We do that.
Okay. All right, those are my questions. Thank you.
Committee Member Ma.
Thank you, Chair. This is a question for staff. So for the compliance hearing option, how is that given as an option after a decision has been made? Is that like given as a form, or are landlords meant to look at the regulations itself to find that information?
It has become standard language in our decisions to offer that. I'm not 100% sure when that standard language went into place. However, it has been available for a while now. I can look into when the standard language went into place as well.
Okay, that'd be great. Just checking to make sure that people know that this is an option, that they can always check back in with the hearing officer saying, I did this follow what you told me to do? Okay, thank you.
Committee Member Balch.
Yeah, thank you. I just wanted to follow up on the previous question from Mr. Cox about the notice form. So absolutely, there are standard forms available from CAA and others to give notice that is compliant with California law. But there is an additional filing requirement for CSFRA, right, to register the rent increase. Is that not the case?
For banked rent increases, they have to be filed with the city. And we have a specific language in the CSFRA regulations that outlines that. And therefore, we have created a template that allows property owners to provide a written notice of rent increase with also that specific language already included in the back of the form, so that they have everything that they need to ensure that they're filing a lawful increase with the banked rent information that is required by the regulations in one form.
Yeah, sorry, maybe I might have been ambiguous. Putting aside the banked increase, I'm thinking back to the 2% issue.
Those forms and the forms only need to be filed with the city if a banked rent increase has occurred. Otherwise, the property owner needs to update the portal with the increase information, but they do not need to file specific paperwork with us if it's just a standard AGA increase.
Okay, thanks. So just to make sure I understand, so there is the standard California filing requirement, and then which would apply to a property in any California location, and then specifically under the CSFRA for Mountain View, the landlord goes to the portal and enters the new rent once they've properly noticed the tenant. Thank you.
That's correct.
Thank you.
Just one more follow-up question. You know, there's quite a long list of these hardship conditions, and I'm wondering whether or not it's legal for a landlord on application for an apartment to be able to ask questions whether the prospective tenant fits in any of those categories.
I'm sorry, can you say that again?
Yeah, I mean, okay, so I'll just talk about the specific case. I mean, this is a tenant whose annual income is far below the $126,000 that is typical, you know, average or whatever for Mountain View. And I'm just wondering, I remember when I rented an apartment, many years ago, they asked me to state my income on the rental application form. And I don't know whether the law has changed since then to disallow asking such questions, because what I'm wondering is, it would reveal that the tenant that he's considering renting to is a potential future hardship case, and therefore it might bias the landlord against offering the apartment to someone like that, as opposed to somebody who's clear of any potential tenant hardship condition.
Yeah, so a couple things. Yes, you can still ask for income on rental applications. But for new tenancies, you cannot, there's no banked rent increases.
No, I understand.
So it would only be in future years if potentially the landlord didn't take a rent increase. And tenants' incomes change. So, I suppose there could be property owners that want to discriminate against tenants based on their income because they're fearful of a hardship petition 5 years from now. But I'm hoping that would not happen.
Yeah, I would like to add that they can set criteria for who they want to have as tenants, but the criteria need to be the same for all tenants. So if they have a policy, you have to earn at least 3 times the monthly rent, or what other kind of policy, they need to equally apply that to all the tenants. So maybe at some point in time, this tenant must have met the criteria that the landlord has set, and now she has a hardship.
No, I understand that, but, just to add, play the other side of this, if, let's just say I were like a student at Stanford, and, I'm in a PhD program, and I know it's going to take 4 years, it's probably reasonable for a landlord to think that that person's income isn't going to change a lot over the next 4 years, not going to go up substantially, right? And so they can play the odds, and I'm just trying to get information to understand, how that plays into the idea of equity here. So thanks. That's why I asked the question.
Just to reiterate, committee member, the banked increases only come into effect if the AGA wasn't given for a year. So if the landlord is giving the AGA annually, the banked increase situation where there might be a hardship petition won't come into effect.
No, I understand that. Thank you.
So I have a question for the tenant. I'm just curious, was there ever a time after, I'm sorry, are we still, okay. So then are there more staff questions? Let's do that. Okay, forgive me, I will wait. Who has further staff questions? I'm going to move on to questions for the landlord and tenant. Thank you. So my question to the tenant is, after the first decision, the first hearing officer decision, and there was the calculated amount of 1416.25, did you ever pay that amount, or did you and the landlord just move on to what was that amount times 2% increase of the 144.50?
I thought we just moved on to the 1444, but I'll be honest, I'm not positive. I guess I could look at the ledger, the payment ledger. Okay, no, it looks like we just moved to 1444.58, which is a 2% increase.
Thank you very much. Do we have other questions for the landlord or tenant? Oh, thank you. Looking at my screen now.
Yes, hi, I have a question for the landlord. When you and the tenant agreed on the 1444-58 following the petition in 2022, did you file a standard CAA notice of rent increase form? Was there anything like that filed? Or noticed?
Yeah, so I'm not muted. First, I want to say that to answer the previous question, the 141625 was paid technically the first 12 months of the lease, from the date of move-in to 12 months later. That's how that base rent was calculated. So we didn't just go to 1444.58. We went to 1444.58 after the 12 months of the 141625. So just to clarify that, the second question, no, there was no written rent increase for the 2% AGA because we thought we were following the decision rule. So there was no written rent increase. I do have a follow-up to Ms. Black's statement about state requirement of us.
I'm sorry, Chair. Would you like to allow his additional statement? Or just
Yes,
the
we'll
answer to
allow
the
it.
question?
Thank you. So if we can hear the landlord's additional, thank you. Mm-hmm.
Thank you. So Ms. Black stated a couple of times that it's not just CSFRA requirements, it's state law requirement that a 30-day written notice be given to the tenant. I agree with that. However, that's not consistent with this last decision, because nowhere in this last decision does it say the landlord needs to give a written 30-day notice to the tenant. So my question is, staff and this decision waiving the state requirement that the landlord must give a written 30-day notice to the tenant? It appears so. And I don't know what precedent staff has to do that.
Through the chair, I can respond to that. So it is not being waived. The language in the hearing officer's decision states that she is exercising her discretion to alter the rent notice that was provided by the landlord in August, and essentially to correct it so that it now reflects the correct lawful rent at the time that the petition was filed, as well as the correct rent increase amount. So it's not that the requirement was waived, it's that the hearing officer is exercising her discretion to correct the notice that was issued.
Committee Member Brown.
Thank you. Okay, this is to the petitioner? No, the appellant landlord. Have you attended any of the workshops put on by the RHC staff?
That question is to the landlord?
Yes.
Yeah, yes, we've attended, myself and our staff have attended many of the webinars put up by the city of Mountain View.
All right. And have you ever asked them questions, like sent in requests for clarification on things with the CSFRA?
Oh, absolutely. We have long lists of corresponding.
So there's an open channel of communication?
Absolutely.
And then are you able to access the FAQs and regulations on the mountainview.gov site?
Absolutely.
Okay, all right. Thank you.
I'd like to ask one more question to staff. So a little bit, this is premature, waiting for the outcome of our deliberations and this appeal. But there's, I think, a pretty good assumption all around that there will not be the banked rent increase. There will only be the AGA increase. And so would it be advisable for the landlord to provide a revised 30-day notice without the banked increase after this appeal hearing is done to the tenant?
It's not in our job description to provide legal advice to the landlord. I will note, as I mentioned, that the hearing officer's decision states that she is exercising her discretion to revise the notice. And it does state in her decision that the lawful monthly rent is, I believe, $1,486 or something like that, which is the amount of $1,416.25 plus the 5% increase.
Right, and that lawful rent commences when that rent increase notice would have been effective, which is why she reformed the rent increase notice so that it could be effective as of that date.
There would be no delay because of the questions around it.
And because with the hardship petition, then you would always have to reissue and there would be a delay.
Thank you. Committee Member Brown.
And so this means that Ms. Williams is eligible to have another rent increase at the same, 12 months after the last notice was issued.
Yeah, so the rent increase became effective October 1st. So 12 months after that, there could be another rent increase where the untaken AGAs could be imposed.
Thank you.
To clarify that comment about untaken AGAs, assuming there is still an income situation so that a banked increase would not be allowed, then it would just be the current AGA.
Right. So if it's a banked increase, the tenant always has the option of filing a hardship petition.
Are we ready to move on to deliberation? Okay. Are there any requests to speak? Oh, I'm sorry, Committee Member Balch.
I wanted to commend both parties, by the way. The landlord and the tenant appear to have a very amicable relationship and are both confused by the technicalities of the law and its execution, and have made good faith attempts to comply and, in my opinion, and to work out a good financial situation. And it's really unfortunate that that despite all that, we are here discussing this. I think it's important to recognize that each of us in our profession, in our day job, does the same thing every day, many hours per week, and so we're intimately familiar with how the mechanics of what we do works. And then when people come into our world for a brief moment to operate with us, the rules are not clear to the people coming into our world, but we are clear because we do it every day. And this applies to every profession, whether you're a plumber, a landlord, or a police officer or anything else. So I'm very sympathetic to people who have good intentions, who try to do the right thing. I believe, based on the testimony from both parties, that there was a mutually agreed 2% increase. But it also appears clear from the testimony that the state notice was not carried out. I think everyone here knows I'm the landlord on this committee. I've made mistakes myself. We all have to become armchair attorneys. I can't tell you how much time I've spent poring through ridiculously detailed levels of regulations to try to figure out what is the right thing to do. But it is the law. I mean, without a written law, we don't have much. And so we have to figure out what are those technical requirements and seek advice to be able to make sure that we are doing the right thing that is sustainable. it's easy to be an armchair quarterback and say what someone should have done months ago. All I could say is that I think it's really important to, whenever there is a possibility of an ambiguity or a question about how one ruling might overlap or supersede or somehow combine with another law that we operate with, I think it's always important to try to ask staff and get as many views as possible. I can't tell you how many hours I've spent Google searching different laws to figure out what to do. And of course, there is the CAA helpline, if you're a member of the CAA, that you can call for their guidance. I think clearly the CSFRA, because it was a charter amendment passed by the voters, is not something that could be simply amended by the city council or certainly not by this group. And it is a challenge that in trying to protect the community against bad actors, there is bycatch, and people who are trying to do the right thing get caught up in as well. So it's a hard pill to swallow, and I've made my own mistakes as well, and I've learned from it. I just think we have to be all. When I say we, I mean everyone in society. Each of us has a right to make sure that our interests are represented and that we use the law as it's intended, and that does require a lot of diligence, of course, to follow up and try to drive out as much ambiguity as possible when these situations occur. So. All my sympathies on both sides, because both of you really communicated, I think honestly, that you did the best you could under the circumstances, tried to figure out what the requirements were, and unfortunately, in this situation, it turned out that there was a gap in the process, and that written rent increase notice, which applies across the board in California, which is certainly true, that ultimately was a linchpin here. So I appreciate both of you coming to the table so constructively. Thank you.
Committee Member Cox.
Yes, so is this the time where we can also say where we stand on the staff recommendation?
I think that would be helpful.
Okay. So I'm going to say that I support what staff has set up, okay, for us to vote on in all the parts. And I want to give a little bit of my reasoning, and most of it's drawn from their own reasoning. I mean, the thing about, I understand, any job or situation that you work with, it could have a lot of different regulations and that you need to follow through on. That are maybe more than anyone would have, wanted, walking into the situation. But I mean, that's the thing. I mean, the occupation or job or position that you have, what comes with it is an obligation to, live up to that. Find as much information as you can, and I mean, seek out help when you need it, and from that point, try to do the right thing. And, we all make mistakes in life, but, we need to accept the consequences of our mistakes, and then we learn from them and go on. So I think the thing about it is, with the 2% thing, I mean, as a landlord who has, I'm not one, but as the landlord has access, okay, to these CAA documents, and, one of the most fundamental things is that if there's going to be a rent increase, you need to send out a notice. That one, I can't write that up to the CSFRA. It's too hard, okay? I mean, that should just have been a part of the normal doing of business. And I just want to underline, as a person who was a renter many years myself and most of my adult life, the landlord-tenant relationship is an unequal one, okay? And the law is in place to try to give both parties a fair shot at justice. And so, that's I mean, so like, hey, let's just shake hands on it and we're done, is just not, it just doesn't go in situations like this. I've been on the other side as a tenant and, you know, seen something happen to me where I just felt the landlord was wrong and felt no recourse to it. And that's why it's good to have written, understood agreements and notices that need to be given. So, you know, I have sympathy that I think the landlord acted in good faith and talking to the tenant, and even when she agreed, you know, about this 2%. But the bottom line is, you know, it needs to be done right. Okay, so that's good. Another thing, though, is just that, you know, the whole idea of going back and recalculating what the base rent should have been. I mean, it's very clear in the CSFRA that, you know, the rights granted in the CSFRA are not revocable, okay? So, I mean, you know, if there's an error found later in terms of, you know, what, you know, a protection from the CSFRA should have been, and it wasn't put forward for any reason, you know, I mean, then correction is in order, okay? And there is actual language in the CSFRA that shows that you can, in the interest of justice, you know, go beyond, you know, the narrow limit of what is stated, you know, in the hearing, particularly if you need to discover information that forms the foundation of the decision. So that's, you know, those are my comments there, and that's why I support the staff recommendation. I will say a few other things. You know, in any case where the language that we have in our documents is ambiguous, or could be said, you know, clearer, or references could be given on where you can get forms to give notices, I really do believe that should be cleared up, because anything that we can do to make things clearer, easier understandable, give references to make things easier for people is a good thing. So I hope that might be something good we can, as a city, can learn from that. And the other thing is that, you know, I mean, I'm trying to get my head around the idea with the hearing officers. I know it was said that, you know, I mean, the decision of one hearing officer isn't precedent for the decision of another. And I think the legal basis that I read is sound with respect to that. However, I am troubled that, you know, not in this case so much, but in other cases where we've heard that there aren't more detailed and consistent guidelines that we can point to for hearing officers to give their judgment. And so we had talked at one point that maybe we'll take that up as an agenda item. And I'm just reasserting that I think that'd be a good thing to do. So anyway, that's all I got to say on this. And I want to thank, I really want to thank both the landlord and the tenant, because, I mean, you know, they've come here without a spirit of hatred and deep animus, which could happen in a case like this. It's one of collegiality and working together. I think that's great. And I'll let the next person speak. Thank you.
I'm in the queue, but I think the chair normally goes last, so I'll ask Committee Member Brown.
Yeah, I agree with what's been said. I think that I also appreciate the collegial atmosphere, landlord and tenant working together on this, but there is a process, there are rules, they are accessible to everyone and visible, and it is something that is up to each of us to follow. And if we don't, if we err, to acknowledge that and deal with the consequences. So, yeah, I would affirm the decision by the hearing officer.
Committee Member Balch.
Yeah, thank you. The only thing I wanted to add was I neglected to then talk about some things I would appreciate in terms of the process. So, knowing that we operate in a very technical legal environment, it would be great. It would be the right thing to do, I think, for whether it's the hearing officer or staff. And I don't. It's always case by case basis. So we just have to kind of figure out. I think all of us, as we proceed, when is it appropriate to interject a little bit of advice for the party, right? So I think I understood staff earlier talking about, in the first instance, there was no waiver of notice in the prior decision, but in the most recent instance, the current decision was to revise a prior notice. So, as explained, I think I understand that I can explain how those things differ legally. I can also understand that those subtleties might be easily overlooked by folks who don't do this every day. And so I think, in all walks of life, when we're the expert, we do this every day, and someone's coming into our world occasionally, a little hint like, hey, you realize that because I just waived the prior decision, you need to file another notice, or hey, you realize that because I am revising the last one, you're good, right? Just a little aside like, hey, here's some coaching to how to get through the process. That type of a culture would be wonderful, just because we all have to have empathy for the people we're working with. Thank you.
Thank you. I agree with many of the comments that have been made previously, and I can see that the agreement on the 2% between the landlord and the tenant was an attempt to get it right, and it's sad that there was the lack of a piece of paper to record that agreement as required by state law. This has been quite the educational situation because it includes rent increases when there were concessions, banked rent increases, and noticing. So, and one of the guiding principles that we've been given in hearing appeals is not that we would have made the same decision as the hearing officer, but is their decision reasonable? And saying that the 2% increase required the 30-day notice to be submitted is reasonable to me. So I'm going to conclude my comments now and go to other commissioners. Committee Member Ma.
I make a motion to accept the tentative appeal decision.
Is there, and we have a second. And so now, Andrea, we're going to vote on screen. Okay. Wait. So now we're waiting to. To accept the appeal.
Yeah, I just think we should clarify because what's on the screen is a little unclear, but the motion was to accept the tentative appeal decision.
So I don't think that changes any of our votes. So I think we're all voting to accept the tentative appeal decision. Okay.
All right, motion passes unanimously.
Thank you, everyone. And I'm going to ask for a 5-minute break.
The meeting is resumed at 8:32. Next slide. Is she there? Did she go to the back?
She's back.
Here she is. Next slide. Thank you. Okay. Thank you, Rental Housing Committee. Agenda item 6.1 will be an update on the CSFRA and MHRSO annual registration and fee payment status. The purpose of this presentation is for the committee to receive an update on the status of the annual property registration and fee payments for the Community Stabilization and Fair Rent Act and the Mobile Home Rent Stabilization Ordinance. For background, each year the RHC adopts a budget to fund the reasonable and necessary expenses needed to implement and administer the CSFRA and the MHRSO. Landlords pay an annual rental housing fee for CSFRA covered properties, and mobile home park owners pay a space rental fee for MHRSO covered mobile home parks to fund the adopted budgets. In January of each year, invoices are sent to property owners, which are due by January 31st. Although fees are charged to fund the fiscal year budget, which runs July through June of each year, the fees are billed in January, which is 6 months into the fiscal year. Right, due to lack of voluntary registration of CSFRA rental properties, the RHC passed regulations in June of 2020 to mandate annual registration requirements for all CSFRA covered units. And then starting in 2021, landlords were required to register and update the information on their rental properties by January 31st of each year. An online portal and database was developed to make it easier for landlords to annually register and update their property information. The database also provides the Rent Stabilization Division with a low-cost method to efficiently communicate with registered landlords. And it offers an online tool for resources for our landlords to comply with program notices and submission requirements. And it also gives staff accurate and timely collection and prompt processing and analysis of rental property data. Both the annual registration and fee payment cycles run from January to December of each year. So that's on the calendar year. To increase compliance with the registration and fee requirements, the RHC adopted regulations in September 2022 to set up compliance and enforcement mechanisms. These include a schedule of late fees in case of a failure to timely pay the annual rental housing or space fee, or failure to timely complete the annual registration requirement. It also includes issuance of non-compliance letters to landlords with a copy sent to the tenants in some cases, and publication of non-compliant properties to the city website. Okay, so let's first review last year's 2023 payment and registration cycle. Since the adoption of the Chapter 12 compliance and general remedies for both the CSFRA and the MHRSO, staff conducted a targeted outreach campaign for that 2023 billing and registration cycle to educate landlords about registration and those newly adopted compliance requirements. So that outreach included 12 landlord-focused annual registration and fee requirement webinars. Some of those were in person as well. We sent out 4 targeted outreaches, including mailings, emails, and information letters. We did some direct follow-up with landlords who had incomplete registration profiles on the database, so they had entered some information. They had started registering, but they had not finished, so we reached out to them directly. And then also we sent out 317 of those non-compliance letters to landlords. And then the second non-compliance letters were sent out to 154 landlords with copies to the tenants, and it was about 1,500 tenants that received copies of those letters. All right, and this chart shows annual fee payment compliance that remains historically high. So over all the years that we have been invoicing since 2018, the average is 97% payment compliance. I also do want to note that invoice compliance percentages are reporting fees collected from the original billing date through January 31st of this year. So past due invoices paid in consecutive years are reflected in the total percentages for the original billing cycle. So that's why you see the older years, they have higher percentages and payments, because each year that staff is doing our collection efforts, we are also trying to collect for previous years' past due payments. Here you'll see that the 2023 registration compliance has increased significantly by 110% from that 2022 rate of 42%. The adoption of the compliance regulation, along with the outreach and education campaign, contributed to the significant increase in registration and compliance. And with the continued outreach of staff throughout the years for non-compliant properties, it's estimated that year over year there will be a continued increase in compliance. MHRSO covered mobile home parks had maintained 100% compliance with both the annual registration and fee payment requirements. And we'll note that having only 6 mobile home parks in Mountain View enables staff to effectively communicate, educate, and support those park owners. And we do that by email, phone, in-person meetings, as well as through postcards and personal letters to those park owners. And then here you'll see the 100% registration compliance for 2022 and 2023. So besides the significant increase in property registration, the new compliance measures that were passed also highlighted some challenges with the system's ability to charge and collect those late fees. The fee collection system required staff to manually calculate and apply fees to non-compliant properties. And this proved to be more time-intensive than initially estimated and resulted in further evaluation for best protocols. So to administer the late fees and fines portion of the compliance measure more effectively, staff started discussions with the registration database vendor, 3DI, and we discussed generating invoices through the system, processing payments, and adding those late fees all through the database. So staff worked with both the Mountain View Finance Department and 3DI, our vendor, and our IT department to identify best practices to implement the fees and fine structure. And starting in July of last year, 2023, staff worked closely with those departments and with 3DI to build in a capability to accept payments through our online portal database. And the new system was built, tested, and released to the public by December of 2023. And that was just in time for our 2024 billing cycle and property registration cycle in January of 2024. So now we'll look at the 2024 cycle. So for this 2024 registration and fee payment cycle, we continued our robust multi-pronged approach to outreach and education in order to prepare landlords for the new fee payment process. So we also sent out our invoices in the first week of January, and it included an information sheet with the information about how to pay online and how to register. And to date, we have accomplished the following types of outreach. So we have had 4 landlord-focused property registration webinars or in-person workshops. We have another one coming up next week. We have had 6 targeted outreach and educational type mailings or emails or informational letters. We've had 1 Mountain View Voice advertisement that has gone out as well. We have updated both of our registration video tutorials. We've updated our online step-by-step user guide, and we have created a new specific page for landlords on our website that talks specifically about registration and fee payment. Okay, so January 31st is the last day in each year to submit your timely annual registration and fee payment. So that's why we're looking through January 31st, and also that is the completion of the last full month that we've had. So this table here shows a comparison of CSA rental housing fee compliance rates as of January 31st, where they stood January 31st, 2023, and January 31st, 2024. So you can see that at the same time in each year, we have increased over last year by 7%. So the next table is showing the comparison of registration compliance rates. And you'll see that those have increased significantly, 106% from the same time last year. The implementation of compliance and enforcement mechanisms paired with the outreach and education campaign that we launched last year and have continued have had a significant increase in the results of higher compliance in the billing cycle and most notably here in the registration cycle. And then I did want to just mention where we stand as of today, the 22nd of February. With fee payment compliance, we've reached 88%, and registration compliance has reached 79%. Thank you. So this table here is showing MHRSO compliance as of January 31st. Sorry, that should say January 31st there on the slide, from 2023 to 2024 cycles. And what you're seeing here of the 6 mobile home parks is 5 of the 6 parks had complied with paying their fee as of this time, January 31st for both years. And here we're looking at property registration compliance for mobile home parks as of January 31st. And what you're seeing here is, again, 5 of the 6 parks for 2023, and then the 2024 number, that's 4 of 6. And I did also want to mention for mobile homes where we are today. With the fee payment collected, we are at 100%, so all 6 parks have paid. However, with property registration, we're still at 67%. So we still have 2 more parks that have started registration, but they have not finished and submitted it yet. Okay, and then finally, I wanted to look at next steps, so what we're doing in the future. So throughout the rest of this billing cycle for 2024, our staff will continue this targeted outreach to the compliance of our annual fees and registration requirements. And this outreach is designed to increase the registration fee and compliance for this cycle as well as for previous cycles. So again, we will be reaching back out to people who have not paid their fees in previous years and try to get them into compliance with that. And we'll also be trying to educate people to make sure that next year they can be on time and successful. And so the planned outreach will include additional registration workshops. Again, we are having one next week. We'll also be sending targeted letters to landlords who have completed part of the requirement, but not all of it. So that's either the fee payment portion or the registration portion. And this targeted type of outreach will not be sent to people who have not done anything. And we've found that that might be because if a landlord has done one or part of the requirement, they sometimes think they have already then completed both parts of the requirement. So we think that's more of an educational opportunity than just a general non-compliance issue. But again, we are also going to be sending out our non-compliance letters. So that first one goes just to the property owners, and then that second one goes to the property owners with a copy to the tenants. And it's meant to be sent out at least 30 days after the first non-compliance letter. It could be, a little bit after that. So we are planning to send those in the next month or so. And then finally, there's no fiscal impact related to, to giving this update. And I did want to then follow up with the committee to see if you're interested in having a short demo to go through what the registration portal looks like, if you want. I'm prepared to do that.
So we could do that right now? I'm interested. I think we're interested.
Okay.
I love a live demo.
Let me just get set up. Yes, please.
Why are you pointing at me?
Can I get out of that? Go back. Sign me out. That's not what there we go. Okay. So this is the test site. So this will not be any real information for these properties, other than it is an actual address in the city of Mountain View. Okay, so the first thing I did want to show is this is the homepage. So the actual site is mvrent.mountainview.gov, and that will take anybody to this homepage. The general public is able to use this search bar here to look for compliance with the registration or the fee payment. So I'll just show you what that looks like. So I'll do this. And an address will pop up. If I click on that, it will take you. It does work. I promise. I tested this earlier.
This is why I love live demos.
I know, it's always something. Here we go. So you'll see here, it gives you the overview of this property. So the APN, it'll tell you the type of property. So this is fully covered. The address, how many units is on this property, and the current year's registration status. So it's in registration open. So they have not registered for this year. And if you look in this little question bubble here, it'll indicate which types of properties are out of compliance if it's past January 31st. So registration open, registration not submitted, or payment pending would all indicate that they have not completed their registration. And then the next section here is the current year's annual rental housing fee paid. So they haven't paid. Again, this is not true for this property. This is just a demo site. And then we list here previous year's information. So previous year's registration status, registrations have been completed on all years for this property. And previous year's annual rental housing fee paid, yes. If they were missing a year, it would say no, and then it would list which years were missing. So that is the searchable function for anybody in the public who wants to go there. And since we are paying and registering all through the portal this year, this information is always up to date. It automatically updates when an action is taken by the landlord. Okay, so if you are, or if I am a landlord and I want to come to register my property, I would click into this landlord button, sign in using my email and password that I've created. If they have not created a password, an account, they can do that here. So then they'll sign in and have a list of all the properties that they have claimed under their account. So if they own quite a few, they can have them all listed here. Especially for property management companies, it's nice they can have them all in one spot. For the sake of this demo, I'm gonna add a new property. This does all my Google auto populates, so I'll delete that. So I enter my APN, 58, and my PIN number. The PIN number it shows up on the invoice, so each landlord would get an invoice that is personalized only to them, and that has their individual PIN number on it. So once I type those two things in, if I'm unsure that I got that right, I can verify it, and the address will pop up here. Otherwise, I can go straight to submit. And this is the property 355 Mariposa that we're using. So we can click into that property profile. And then you'll see here, this is sort of the main page of the property profile. It has a picture. If anybody wanted a new picture, they can add one. And then this fees section is where fees will be displayed. However, fees will be calculated after a property has finished registration, and that's because if there are unit exemptions on the property, we want those to be submitted first so that it can be deducted from the total fee. So you'll notice there's some tabs up here at the top. The first is that same overview that the public can see. The second is the property information, and third that is required is the contact information. So an owner information and manager information has to be submitted. Date of initial occupancy, so that's either before or after February 1st, 1995, which would indicate if the property is fully or partially covered. I'm just going to enter in any information here. 2024, and then if I scroll down, I type in my home address. And at my preferred method of contact here, so I can do a mail or email or both. And for my mailing address, it can either be something different. If I want my bills and things to go to my property manager, I can put that there. Or if it's just me, I can do that. Click same as home address. And once I submit that, that just pops up here on the screen, easily edited, easily deleted. Next, I will add my manager information, and it is indicated here with this red dot that something is still missing. So I'll type this all in, or I can just click same as owner for time's sake, and it will auto-populate there. So that adds in, and now there's no more red dot with exclamation point, so we know we're okay. The next step would be to update my unit information. If none has ever been entered, we just start from scratch, but this property has done it in the past. So if nothing has changed and we look okay, we can just go ahead and submit. If anything has changed, say this is not vacant anymore, we want to go ahead and edit that information. We can switch that into a tenant or a manager or owner. 1 bedroom, 1 bathroom. Move-in date. Date of last rent increase. So this one, if it's too soon and there has not been an increase, it instructs you here just to enter the same information as the move-in date. Current monthly rent. Last monthly rent increase. There hasn't been any. If anybody needs help with calculating percent changes, we have a link here for them. Then we'll just update that, and then it will change there for us. So now we can say everything looks good. And you will also notice, just quickly, since we're in here, I'll show you. People can apply for exemptions. They can also submit those termination notices, submit buyout agreement information, banked rent increase notices, all here on that per unit level. So I'll just say that is okay. So I'll go ahead and review and submit. I take one look over. Everything looks great. I'll submit again. And then here's just really a reminder, we want to make sure nobody skips by their exemption requests if they have any, because we don't want them to overpay. So they do have to do an action by clicking this box to really acknowledge that they have submitted their exemptions. If they haven't, we can go back and fix it, but we want to try to get them to do it before. And just a short declaration statement here. And then they can enter in their full name. There we go. And select the title and submit. Then you'll see it'll change into payment pending status because we have registered but we have not paid. And the fees now will pop up here. So we can go ahead and say, okay, everything looks great, let's pay. We would like to pay. And then I'll just get a test credit card. Copy that. What's the next year? There we go. Then we can pay. I didn't get that right? Oh, I had to put one. Now, there we are. Now I'll pay. I won't save that. That's not real. And here I can download my receipt because I've paid. It's just a very simple receipt that has the information of the property and how you paid and when you paid and how much you paid. Okay, and then you'll notice now it just shows a constant that you have paid, you have no balance due, and that this has changed into a payment received status. On the back end, staff will do a once over and just double check everything, make sure nothing looks too much like an error. If everything looks okay, we'll go ahead and complete this registration. It will stay green and it will move to registration accepted. But payment received is also a completed status. So that's just a very quick demo. Thank you. Any questions?
That was 5 years of sweat and tears.
Any questions about this or the memo?
I'm sure we have a few questions, and I'm going to switch to the queue so I can see the queue. Committee Member Balch.
Thank you for the presentation and congrats on a good demo. That's a beautiful site and I know it represents a lot of work. So thanks to everyone, the staff for all that. I have a question on the practical impact of non-compliance. So I read in in your staff response to the committee's questions that at this point in time, while in theory there could be a legal action that would require authorization by the city council. So I'm just wondering if a landlord does not comply, let's say a tenant were to file a petition, but there would be no information, and maybe the hearing officer decides in favor of the tenant because there's nothing, they're out of compliance. Effectively, does this go to small claims court where the tenant has to sue the landlord, or what is the actual end effect of non-compliance?
So non-compliance, you mean not paying the registration fee?
Well, basically ignoring, well, yeah, so not paying the registration fee and therefore not being able to go through the CSFRA processes because no information's been entered.
Right.
Yeah.
So, the primary end effect is that the landlord is not eligible for any rent increases, and the tenant can petition for a downward reduction in rent, and our decisions are enforceable by the tenant. The tenant gets an immediate rent reduction and, can collect the back rent. Typically we give rent credits as
right, and so then it would follow a normal process where if there was of a legal dispute between the tenant and the landlord, the tenant would need to initiate a legal action?
Well, we hope that through the petition process, they could avoid that by getting the rent reduction and a rent credit for overpaid rent. So I don't want to call it self-help because it's not self-help, because the hearing officers issued a decision. But the way the decisions work is the tenant is then entitled to pay a reduced rent, and typically if they've overpaid for several months, they get a credit on their next rent payment. And, the landlord could, I guess, try to evict them for underpayment of rent, and the tenant would then have an affirmative defense of our decision saying.
Interesting, but are you then saying that, let's say that the landlord does not register, but is somehow following the rules about rent increases, and so let's say hypothetically that the landlord is charging a rent that would otherwise be legal or compliant, they're just not following the process?
Well, so if you're not registered, you are not entitled to any rent increases.
Okay, that's it.
So if you gave a rent increase, even though it was in compliance with the annual general adjustment, that is not allowed.
Thank you. Thank you.
And that's part of the reason why that second compliance letter goes out with a copy to all the affected tenants. And the second compliance letter says, in short, if you've received a rent increase, the property may have been out of compliance. Please contact our office, and then we can look into that more with them.
Thank you.
Committee Member Ma.
Thank you, Chair. To the fee compliance table for the CSFRA, we see that it's obviously never been 100%. Does staff know in detail about this, stragglers of 2% who are still refusing to pay the fee?
There are some properties, very few properties, that we have not been able to get a hold of. We have looked at the county database, we've looked at the information that the city has for utilities and other places that we've looked, and we haven't seemed to get a hold of some people.
We know there is a physical building there.
There is a building.
We just don't know anything about how to reach the owners. Correct. or try reaching the tenants.
We send out those second compliance letters, and nothing. We try very hard to find them.
Committee Member Cox.
Yeah, that's kind of amazing. I mean, not being able to, I can understand that if you can't get a hold of the landlord, clearly the tenants know who to send their payment to, right? So there just should be some way of getting a hold, but it's just you're saying that there's just no communication back.
Right. So we send out the letters to the units on the property, but that's all we do. We don't actually go, to the properties and try to engage with the tenants. So if they're not engaging back with us, then it can be
I
hard.
mean, I've been through cases before, like, and we discussed things in the Old Mountain View Neighborhood Association about properties on Castro where the city has told us that, their property taxes on auto pay and the owner is in another country and that's just it, Like we just can't, beyond that, we can't find them to ask them why have they left the building vacant for 10 years, So I can understand part of what you're saying about that, but I mean, I think that, I really believe that, I look at the great progress that you're doing. I see the numbers going up. I do, though, compare what's happening with the CSFRA with the mobile home ordinance, and that one's at 100% and the other one's not. And, just in general, if things start to plateau, I've said it before, I'd like to see a study session on the agenda of us discussing the whys, some details, and what else we might be able to do about it. I don't even know whether or not, for instance, like when I get my property tax letter, maybe some cute thing like they do where they say it's due on February, but you get the penalties assessed if you don't pay by April. That might get the late compliance thing into, a better situation. But I'm just kind of surprised at how many people are late. I mean, they do pay, many of them, but why be late? I mean, when I get my property tax statement, it says right on there, right? I mean, you are out of compliance if you don't pay by this date, and here's what you're going to get charged. And I think, all that kind of information you can do is a good thing. One small question beyond my comments. How do you get the pictures? Are they coming from Street View?
Yes, they are.
And you've cleared that's okay? Or
Our vendor.
Okay, it's through the vendor, and it's his responsibility to clear that's okay, because I know I've seen pictures on Street View from time to time where stuff is blurred out.
If it's blurred on Street View, it's blurred on here.
Okay, got it. And then, but they have the choice of supplying a different picture if they want. Okay, that's good.
And then just to address the previous comment, the invoices do state that there are late fees if it's past the due date. And it's also stated again on the information sheet that goes in front of the invoice. So it's twice on the information that they're receiving.
Okay. Yeah, my biggest concern is that as time goes on, if we're still having people that just don't, they're completely ignoring the process, and I don't care if it's because they think it's on principle or if they just don't want to pay. Okay, but I think that, that whole thing about they can't increase the rent is a big incentive to get around them. So thank you.
I'm curious about ways of using the system. And so if a landlord wanted to, there are two ways to update registration that I can imagine, and I don't know if they're both valid. One would be every time a new tenant moves in, or just whatever is going on that you're updating. And then the other one is one big data entry project every year. Are they both valid options?
Correct.
And then, so once a year, you just have to click some extra buttons and say, I certify this?
Right. So if you keep up with your information all year, by the time January rolls around, you just have to click review and submit. Okay. And submit that. Otherwise, you should be updating the whole property and then submitting.
One other question. In the test system, all the names said tenant, tenant, tenant. And in the real system, is it actual names?
No, we do not ask for the names of tenants in each unit or contact information.
The options for that field are tenant or exempt?
Tenant, owner, manager, vacant.
Thank you. Oh, Committee Member Cox.
Yeah, just one follow-up question. I really love the demo, I appreciate that because, I'm can't wait to tell the people in my neighborhood association about it. Those who are renting would like access to this kind of information, and the landlords I know too. Might appreciate it as well. But I'm wondering, just so that it's clear, the information that you have, about the properties and stuff like that, it's only the landlord who's entering that information, right? It's not the tenants supplying it, right?
Correct. It's
Okay,
the landlord
okay.
or their manager.
And is the expectation that, like, when a tenant leaves or a new one comes in, you would update it at that point, or you just need to update it, once a year, based on, what it's been since the last compliance period? How does that go?
As far as rent increases go, that's once a year. But there are other requirements in our regulations where if a new tenant is coming in, you're to update that information within 30 days.
Okay.
If you're serving termination notice, or if a tenant is leaving, you're to update that information because you're already giving us some of that information anyways, so it will automatically update the system. But the same is not in the regulations for rent increases.
Okay, thank you.
Committee Member Ma.
One last question. So for the, in the documents you provided, the sample compliance letters, are they in different languages?
They're all in different languages, but I just didn't include all the languages. It's Spanish, Mandarin.
So we
Russian.
know for each property like this, or do we just bundle all of them in? And,
Yeah.
Okay.
I'm not seeing other questions at this time. So I think, we should go to public comment. Are there any speakers online? I think there are none in the chambers.
No speakers online. Oh, there is, sorry. Let me switch over.
Are there any speakers who wish to comment? Okay.
There are. I just need to switch back over to my timer. There we go. We'll go ahead and ask B. Hansen to unmute.
Hello, can you hear me?
We can.
Question. Apparently, a couple of the mobile home parks are not 100% in compliance, are incomplete records. Doesn't that mean that the residents of those parks, which are Sunset and New Frontier, I think, that they don't have to pay increases in rent? That's a question. That's all I have.
Should I respond? That means during this time that the landlord's out of compliance, so January 31st until they register, they're not allowed to give any rent increases. If they do, then the tenant should contact us and look into a petition.
Okay, thank you.
And do we have other speakers?
No other speakers.
Okay. Do we have other comments before we move on? Okay, thank you very much. And we will move on. Our next item is 6.2, CSFRA and MHRSO financial expenditures for fiscal year 2023 to 2024 through December. And we will have our presentation first.
Thank you, Chair, Rental Housing Committee members. Next slide, please. The purpose of this quarterly overview is to keep the Rental Housing Committee informed about the financial expenditures in the last months from this fiscal year, both for the CSFRA and the MHRSO. The budgets for this year were adopted by the Rental Housing Committee in June of 2023 in the following amounts. As displayed on the screen. These are the final amounts after you approve them based on final salary and benefit calculations. And the following information is provided over the 6-month period, July 1st till December 31st, which is 50% of the budgets. We provide the following key categories: personnel services, which includes all the staff of the programs and hourly paid wages. The non-personnel services include advertising material, office expenses, but also consulting contracts that we have. The capital outlay, we currently still have a reserved amount for the database that we are slowly spending. And the interfund expenditures are costs that we pay to the city for provided city services, such as HR, IT, and all the other departments, the use of the facilities, etc. So this gives an overview of the CSFRA expenditures per category. For personnel, we are at 40% of the personnel budget due to personnel hours charged for other services than directly related to the CSFRA. This could be tenant relocation assistance, other services provided for other departments that we don't charge to the CSFRA. The non-personnel, we are currently at 17% due to lower advertising materials and supply costs and consulting services costs. The capital outlay, we have spent 10%, and this is used for ongoing development of the database registry. They're still always working on certain implementations, and so we keep spending that money that is still on the budget for coming projects. And then the interfund expenditures and transfer have been 100% paid to the city. They usually charge that midway through the fiscal year. Then we give an overview of these key categories as a percentage of the whole budget. So currently we are at personnel services at 20% of the total budget. The non-personnel services at 6% of the total budget. The interfund transfer is 9%, and we have an 0.4% for capital outlay, and the budget remaining is 64% for the remainder of the year to be spent. So we're definitely under budget. The following table gives the MHRSO expenditures per category. For personnel, we are at 55%. The personnel has done a little bit more work than was expected due to performing work that otherwise may have done by consultants. In the non-personnel, we are at 13%. Less advertising materials and supply costs, as well as consulting costs. And the interfund expenditures have been spent 100% midway through the year. And again, as a percentage of the total budget for the MHRSO, personnel services comes at 25%, non-personnel 6%, interfund transfer 9%, which leaves 60% of the budget remaining for the rest of the year. So there's no fiscal impact on receiving this quarterly overview of the financial expenditures, and we, per the request of the Rental Housing Committee, will be returning on a quarterly basis to update you on these incurred expenses compared to the annual budgets. This is the end of the presentation. Happy to answer questions.
Thank you. Let me switch to seeing my queue of questions. I am not seeing any questions at this time. Are there any speakers online who would like to speak?
There are no speakers online.
Okay, if anyone would like to speak, they should raise their hand. I will comment myself that I like this presentation. I like the mix of the numbers and the pie charts, and I liked seeing that there was a significant amount that we were halfway through the year with more than half of both our budgets left. So very soothing. Committee Member Cox.
Yeah, I just wanted to echo that and also to say that, you know, I did send in 3 questions and they were fully explained, and I don't see there's need to take time here for them, but I just want to say thanks.
Committee Member Balch.
Yeah, the absence of question, I think it was just really well prepared and self-explanatory. So as you went through it, it was very clear and no questions required. So thank you for that diligence.
I think we're ready to conclude this item. Our next item is 6.3, Rent Stabilization Division Fiscal Year 23-24 report through December 31st, 2023.
Thank you, Chair Keating. Good evening, committee members. This agenda item is an overview of our Rent Stabilization Division activities through the midpoint of the fiscal year, which is December of 2023. So the purpose of this is for you to receive an overview of the division activities through the midway point of the year. And this is what that report looks like. We have our first page that really focuses on our outreach and education program. The second page goes into property detail for the CSFRA program and registration, rent adjustment petitions, and then what's happening with the Mountain View mediation program as it relates to the Rent Stabilization Division. Next up is information on our Housing Help Center, and then we follow that up with information on eviction prevention, tenant relocation assistance, and property sales for fully covered units. We then move on to mobile home specific information. And then finally, we wrap it up with market conditions for apartment complexes. The market conditions do not go into detail for mobile homes. We are unable to retrieve that data from the service that we use for this. However, we can start pulling some information from our portal coming up. So we will start probably in the next fiscal year having more information about mobile homes, and that is exciting. So we will go into a deep dive of these since we're only receiving this report every quarter, and we'll start with our outreach and education program. So highlighting the information requests and inquiries, we've received about 1,400 at our midway point. 16% have been for Spanish language assistance. And you can see here right now, there is more than half that have been tenant-based, and 431 landlords have contacted us. We've received the bulk of these contacts by phone calls or emails, and they've been resolved in that way as well. We are averaging pretty close to what we averaged last year in terms of this time last year. So we will likely continue that trend and, you know, see a flattening out of how many people we're contacting and how many people are contacting us. For inquiry topics through December 31st, you can see that tenant petitions are the highest number of inquiries, followed by property registration inquiries. And then the next is allowed rent increases. For community outreach, we have given 6 workshops with 50 participants, and 4 of those have been bilingual in English and Spanish. There have been 24 office hours held. So every Tuesday, we hold virtual office hours for property owners and tenants to join us and get their questions answered in a virtual setting. We also have open office hours for tenants and landlords and anyone in the community to come in whenever our doors are open And as you can see here, the community does do that. We've had 207 people walk into our office in the past, well, through the 6-month mark. So that's more than one a day. So we are very busy with walk-ins, and we've had 77 appointments. 43 outreach events have been attended, and we've reached nearly 2,000 community members by going to these outreach events. We've had high success with really building the trust in the community by attending these events, and people see us there and they come to us, and we learn about some very challenging situations in the community because of our ties to the community. This is what it looks like in terms of the types of documents we're creating, how many website pages we're maintaining, the number of forms and informational documents that are being changed, updated, drafted in additional languages. We've had 4 Mountain View Voice ads so far. And then for mailings, you see here, some of this is some of those specific landlord and tenant letters. Those are our targeted mailings. So we send these out, if you recall from our conversation about outreach last month. We send out targeted mailings to tenants and landlords for people who have received eviction notices, for compliance, among some other issues as well. And then we send out mass mailings too. So postcards and flyers go out, newsletters. We're just about to send out another newsletter. We sent out some postcards related to registration and related to compliance. And those are kind of picked up in the past few weeks. So the next quarterly report in Q3, you're going to see a lot more happening in this section. And then for email updates, see how many different types of emails we send out and how many subscribers we have. And we do try our best to provide as much information as possible in the 3 or 4 main languages of the city, in English, Spanish, Chinese, and Russian. So here's some detailed information about our properties, how many are covered, how many units we have in that. And then for our registration cycle, this is the 2023 cycle, what our compliance rates are. So 88%, as you now know, from all of the different places that you've seen this number, for the number of properties registered. And then for rental housing fees paid, 95%. And so again, this is another data point that will change in our next quarterly report. You will see information for the 2024 cycle, which is what we're now in. So if these numbers drop, it's not because something happened to our 2023 cycle, it's because we started a new cycle. And we will definitely remind everyone of that when we take a look at these numbers again. For rent adjustment petitions, we've had quite a few filed this year. Through the end of December, we had 41 petitions filed. So you can see we're quite high on that compared to our other years. At this point in the year, I think last year we had only 17 filed. So we've seen a significant spike. We're now at 58 petitions filed with the city. And most of them are tenant petitions for unlawful rent and habitability issues. We've also had a few compliance petitions this year. And then for mediations and conciliations, we have 46 mediations and conciliations that have occurred so far this year, and 39 of those are resolved, with only, I think we might need to double check this number. I think it might be 7 that are pending, but I will double check. And now for our Housing Help Center information. So this is the high-level overview. We have split the Housing Help Center for the first time this year, a few months ago, into being one for tenants in the evenings on the first and third Thursday of the month, and one for property owners on the first and third Thursday of the month at different times of the day. So landlords can come to our office or join us virtually from 1 to 3 on the first and third Thursday, and tenants can come to our office or join us virtually from 6 to 8. So for property owners, we've held 5 clinics, and we've helped 8 landlords. This number has jumped up because we had quite a busy month last month with property owners coming in with needing information on registration. And the top three reasons at this point in time were allowed rent increases, property registration, and eviction protections. Now for the tenants, we've held 12 clinics. We've helped 78 tenants. And the top three reasons are rent assistance, affordable housing, and below market rate housing, and legal assistance. 46% have required assistance in a language other than English. 57% heard about the services through the community. 47% have 3 or more people in their household. And the majority, 84%, live on an average annual income of less than $54,000 annually. At our help center, tenants can come into the help center and receive additional contact with housing-related support services, including the Community Services Agency of Mountain View and Los Altos, and CLESPA tenant organization that provides legal assistance for tenants. So for CSA, 10 of the households that were in need of rental assistance received that assistance through CSA for an average assistance of $5,600. And for those who had questions about legal matters, 56 tenants received free legal advice from CLESPA. Of those that received legal advice, 82% had received a termination notice. And then specifically, 13 households received actual legal representation that allowed them to remain in their home. So there is a difference between these two. The 56 tenants that received free legal advice were able to then self-advocate and use what they learned to help them take care of whatever matter it was on their own. And then specifically, additionally, those 13 households that received actual legal representation allowing them to stay in their homes in the face of eviction. On to more information about noticing and terminations. So we've seen 52 banked rent increases notices, 647 termination notices so far. This is a little higher than typical. 1 tenant buyout notice and 1 additional occupant notice. Now you can see the breakdown here from fiscal year 18-19 through today for no-fault evictions and then for at-fault evictions over time. We then have a further breakdown for failure to pay rent notices, and then a further one for the actual past year based on the quarters, and 383 unique households. So individual households, we have separated them out from the total number of notices that we've received to be able to say that 338 in this past year that you see here were for unique households. And tenant relocation assistance wise, you can see that like we've talked about in the past, things really kind of ground to a halt back here in 2020 when the state law SB 330 went into effect. And we have no properties in redevelopment, 0 units affected. And then we have 1 household that received assistance for an outlying reason other than a major redevelopment on the property. For sales of fully covered units, we're pretty far below our average here, with 5 having been sold. These are not sold in, again, these are not sold for redevelopment. These are sold just between property owners who wish to maintain the property owning business and have rentals, for a total of 51 units, again, below our average. Right now, there's 1 property for sale for a total of 24 units. And then we have our mobile home coverage. 6 parks, 1,130 mobile homes. You can see here we have the number of mobile homes that are rented versus the number of mobile homes that are owner occupied. And for the 2023 cycle, 100% of parks were registered and 100% of them had paid their space rental fees. We received 8 information requests from the public for the MHRSO related matters, and the top inquiries were about the registration portal. For rent adjustment petitions, we have not received any this year. And for evictions, you can see there's no fault evictions, and there have been some failure to pay rent evictions. And for market conditions, this is about to wrap up our report. We have our average market rent. This is again for CSFRA covered units only. You can see here the different types of properties. All units are here in yellow, so that's an aggregated total of these here, and then averaged. Fully covered units, the average market asking rent is $2,627. And then you can see a further breakdown of this for fully covered units since the law went into effect by quarter. And then the actual market rent broken down by number of bedrooms for fully covered units. And we have the vacancy rate broken down in a similar fashion. So newly built, partially covered, all units, and fully covered units. And just for a quick reminder, the vacancy rate for newly built units is an unstable marker. It's erratic because of the way that the units are reported when they come online. When a new building goes out into the market, they report that at whatever vacancy rate it is when it first opens. So it could be a 100% vacant because it just got built, although usually there's a little pre-leasing, so that's not typically what we see. But that is why there are spikes. And then when there's not a building that's been just opened, it flattens out. And then again, same thing, we have our fully covered vacancy rate from the start of the CSFRA implementation, and then how it's broken down by unit size. And this concludes staff's presentation on this matter. Are there any questions? Staff would be happy to take.
We have some questions. Committee Member Ma.
Yes, I have two. For the at-fault evictions over time, we see a rise in notice to cease evictions. Do we know anything about why?
Notice to cease are not eviction notices. They're the step that property owners have to give before notice of eviction goes into place. So it's an opportunity for the tenant to address an issue before it actually results in a termination notice.
Okay, for a subsequent question on that is, has any of these notices actually gone to trial yet for an actual eviction UD?
That is a good question. Andrea, do you happen to have any insights into that? If we've seen any information in the database.
I would have to look at the specific UDs that were submitted. I know of at least one, but.
And I also want to add, it's really hard to track. The court does not usually give out information about that type of cases, and not per city either. So it's still really hard to track.
Okay. And on the rent adjustment petitions, I probably missed it when it was discussed. What's with the other category?
Sure. Go back and take a look at that. Here we go. So the other category, when you're looking at this, it's tenant, landlord, and then others. So we have a couple types of petitions, like the joint petition for new or additional housing services, and then compliance petitions. So they're not strictly a tenant petition or a landlord petition. That's why they fall into that other category.
Do we have any insight on what the joint petition is used for?
So the joint petition is used for adding new or additional housing services in a lawful way to current lease.
Okay, I mean,
so let's say you wanted to have a dog, you wanted to add a dog to your lease, you can work with your property owner to fill out this type of petition.
Those are all my questions.
Committee Member Cox.
Yes, I was looking over at the, I may have answered my question. You can confirm whether I've got the right understanding now. On page, slide 70, section 5, eviction prevention, the charts on the bottom of the page, there's one, failure to pay rent notices over time, and another on the right, failure to pay rent notices. And I think the deal, what I was wondering about is it looked like the bubble chart or whatever, I mean, graph or whatever was going down, but the other numbers looked like they might be going up. But I think really what's going on here is that, on the right, we just have two bars, and if you add them together, you get that number that's the last point. And then you'd need the previous, well, I don't know. It's quarters versus fiscal year. So it means that if I go back enough quarters, what I'm going to see is that the downward trend that's not obvious just looking at the last 4 quarters. Is that right?
So I think one way to think about it is that this is fiscal year to date, and these are the actual full fiscal years. So the 627 that you see here is just through the halfway point of the fiscal year.
Okay.
And then we also show it broken down over the past year. And that's a roll, these ones change. So next month you'll see Q4 2023 through Q3 of 2023-24. So you'll see that those ones change because it's rolling.
I got it. So I think a key thing here is that on the chart that's on the left, the last point is fiscal year to date, and so it doesn't include the full numbers, right?
Yeah, because we don't have them yet. Yeah,
All right,
so at the
so it's
end
not
of the
an
fiscal
indication
year,
that
you'll
things are
have that.
going down. It's just,
Right.
that's partial data. Okay, so thanks.
Right.
I guess the other question is I'm looking at the rents for the newly built units and on fully covered units, and if I look over since the last report, which I guess is 6 months back, it looks to me that on the newly built units, rents are up 0.5%, and on fully covered units, they're down 0.4%. And so, but the AGA in the last 2 years has been 5%. And so my question back is, it seemed, I would take that to be just a sign of just general market demand weakness as to why the AGA is higher because, but that, the rents aren't going up with the AGA. Can you comment on that?
I just want to say the market rent is different than an existing rent for current tenants. Market rent is when a unit comes back on the market and the landlord can ask any market rent that he thinks is a good number for this new unit. So we call that vacancy decontrol. Yeah. So these are market rents. This is what the market is doing. It does not
But I'm talking on fully covered units here. That's not a market rent, right?
So when a unit becomes vacant, the landlord can start with a market rent.
I see.
And then they are subject to the CSFR.
Okay, so then when you quote the rents for the fully covered units, you're saying that's the market rent for new move-ins,
Yes.
not the average rent that people are paying.
Correct.
Okay,
Yeah.
got it. Thanks for that clarification. And can we make comments now, or are you going to wait for those? Okay, that's for the chair.
I'm happy to have your comments.
Okay, then the
I
only
believe we have to have public comment too.
Oh, so you want to wait then?
Okay.
Okay, that's all the questions I have. Thank you.
Walsh.
Yes, thank you for this report as well. Are there any notable outliers or surprises that the staff sees in this report that you'd want to draw our attention to specifically, or is it basically as written?
It's basically as written, unless you have any specific areas that you would like clarification on, which we're always happy to provide.
No, thank you. Looks fine. Thank you.
I'm curious about the 52 banked rent increases. Was that from just a few properties or many? I don't need an exact answer.
I would have to go back and check the data. Andrea, do you have any insight?
It's from many properties.
Thank you. I'm not seeing other questions, so let's go to public comment. There are no speakers in the chambers. Are there any online?
No online speakers.
So now we're ready for comments. Committee Member Cox.
Yeah, I mean, my main comment on it, first of all, thank you very much for this report. I really look forward to it coming out each time. It's one of my favorite reports to read because it gives me, as I've said before, it gives me a sense of the health of our community in terms of like people's ability to manage, the rents and being able to stay here. I thought that it was interesting to see that on the newly built units, like I said, they're up from the last report only 0.5%. On fully covered units, they're down 0.4%. And the vacancy rate for newly built units is down from 12.2 to 10.5 and up from 5 to 6. And, what I was told by landlords that I knew back in the day is that a 5% vacancy rate is kind of like where they'd like it. So I think that's good on the fully covered units. The other thing is that, that whole sawtooth thing that was going on for the new units, I'm glad to see that it's gradually stabilizing and moving down from over 28% down to 10.5%. So that shows that there are people who are willing to move into a lot of this housing that's was just being constructed under COVID and is still being constructed. So, one thing, it's out of the purview of this committee, but it does make me ask the question, well, who's moving in? Are the people primarily people who are, living and working in Mountain View, or are we becoming a place where people are living here and then they're going to drive somewhere else? So I don't expect you to ask that. I just raise it as an open question for any researcher listening who might have the answer for me. Okay, so that's all my comments. Thanks.
I'm not seeing other speakers. So thank you very much. I think we can conclude this item. And then moving on, we are now on item 7, committee staff announcements and updates. And we will go back to staff for another presentation.
I will begin with agenda item 7.1, upcoming office hours and workshops. So we continue to have our virtual office hours every Tuesday from 10 a.m. to 12 p.m. Where people can join on Zoom at the link there. And then we do have the end of February workshops coming up here. So these are all next week. As I mentioned before, we do have our property owner registration and annual fee. This one will be in person at our offices at 298 Escuela at 2 p.m. And then on the 29th, which I believe is Thursday, at 2 o'clock, we have upcoming changes in utility billing, and that one's going to be landlord focused, and it will be virtual at the community center in the Willow Room. And then later in the evening at 6:30 p.m. for tenant focused workshop about the same topic, changes in utility billing. That will be at the senior center. Okay, and then we'll just highlight our housing help centers here to wrap things up. So we have our landlord-focused housing help center. Again, these are every first and third Thursday at our offices on Escuela. The landlord help center is from 2 to 3. It is either in person or people can join virtually on Zoom. And we help them with anything related to rent stabilization, evictions, rent increases, compliance issues, or if they have questions regarding petitions. And then following in that same evening, every first and third Thursday at our offices as well, but this is from 2 to 6 p.m. is our landlord-focused housing help center. Also hybrid, people can come in person or join us on Zoom, and they can learn about all sorts of housing programs, anything related to rent stabilization, or if they're interested in signing up for affordable housing programs through the city, we can assist with that. Any eviction protections help they may need. We also have the ability to refer people to legal assistance there if they've received termination notices or unlawful detainers. And there's also additional support services, especially through CSA, where people can learn about rental assistance, food distribution programs, homelessness prevention type resources. So that's all there at the Tenant Help Center. And that concludes the upcoming workshops and events.
Thank you. Switching over to my queue. Do we have questions on this item? So, do we have public comment on this item?
No.
Okay. And then our next part of item 7 is 7.2, expected future agenda items. And so upcoming will be a annual overview of TREO and SB 330. And Committee Member Ma.
Thank you, Chair. On 7.2, I noticed that the study session for anti-harassment was missing from this agenda that was marked in our work plan for this meeting. Is there a status update on that topic?
Currently, it is being discussed whether or not this would be in the purview of the Rental Housing Committee versus the City Council. So there will be discussions soon, and we will let you know what the recommendations are coming from legal.
So that's the determination from the city's attorney's office or from the city manager? Or?
There is no determination yet. There will be discussions.
Okay. Is there a timeline for that, or is who knows?
Whenever we get an appointment with the city attorney's office.
Okay. Thank you.
Okay, I think we're getting close to adjournment. Any other questions first? Okay. So looking, it's almost 10 o'clock, so we adjourn at 9:55. And the next Rental Housing Committee meeting is scheduled for Thursday, March 28, 2024 at 7 p.m. Thank you, everyone.
I'll look into. I'm seeing a lot of trends in higher nicotine and marijuana use, especially with the advent of vaping technology, right? And yeah, there's a prevalent idea that since they think it's not